find hard to spell his picture, his campaign picture.
No, who do you want to go first? Mr. Powell, are you ready on Benjamin?
I am. Is this Tiffany?
Yes.
Happy birthday.
Happy birthday, Tiffany.
Oh,
That's my case. Is Mr. Benjamin?
Hold on,
Custody?
hold on. We'll
Yes.
let you know who we want. Just a second. We're gonna try to get Mr. Benjamin. Michael Haynes is the one on in the waiting room. I'm admitting him now.
Excuse me.
No, you can't talk unless they call you case or they ask you. Okay? If you want to talk, you talk to your attorney privately. Now, not only that everybody else that's on can hear you, you might say something that your attorney wouldn't want you to say. And number three, you're live on YouTube. Okay.
Ms. Burton, are you ready on Aaron Johnson? Are you on that case?
No, I'm on Mr. Michael Haynes.
Okay.
Yeah.
And he's the one that was Galaxy S9.
No, Judge, Mr. Haynes?
No, he's been on?
No,
No.
he's been on.
Michael Haynes, his name is on there, Your Honor.
Okay.
Who's on Aaron Johnson?
Aaron Johnson,
I
who's
think that's
on the attorney?
Mr. From the state. I think it's Mr. LaRue.
All right, let's move on to somebody else. Can we do Michael Haynes? Who is the,
That's Mr. Lorenz from the state, Your Honor. And
okay, Mr. Lawrence is not present either.
Your
Okay,
Honor, it's an arraignment on a petition to revoke. Can we just arraign him with one of the state's attorneys and I can text Mr. Lorenz?
okay, I need to know from Mr. Lawrence whether or not he's going to ask for bond, things like
Okay.
that. And if he asks for bond, I need to set it for it.
Let me text him, Judge, and I'll get back.
For an in-court hearing.
Yes, Your Honor. Thank you.
Okay.
I'll
send him
reach
a
out to
message
him.
as well.
Thank you.
I sent him a message, Your Honor.
Okay. A lot of good that would do.
Eduardo, were you able to send the agreed order in?
I need to print it and sign it.
Okay.
And then I will email it once it's once it's accepted, and then I'll email it to the clerk.
Okay.
Uh,
We can probably call Miss Harris. It's also that's with Mr. Lorenz as well, but it's just an arraignment.
Regular arraignment on
Yes, Your Honor.
civil offense? Okay.
Yes.
Wait, is that Harris? I have that as
Passion Harris.
that's either Miss Doyle or Mr. Humke, I thought, and I sent Miss Doyle a message. So
Oh, okay.
get back.
Yep.
Let's wait until the proper attorneys are present.
I think we can call Pratt. It's a non-custody.
There is enough confusion. to begin with.
Eduardo, sorry, Your Honor. Eduardo, we need the order for that.
Oh, let me go do that now then.
Yeah.
As I said, there's enough confusion to begin with. Let's not extenuate that. Jail, anyone from the jail that I can call? Mr. Quilt has been here since 8:30. I've seen him.
We only have one custody in the jail that's ready, and it's Johnson.
Johnson is ready, folks. Who's got Johnson?
Your Honor, I believe that's Mr. LaRue. I'll see if I can ask him to join the meeting.
It might be a good idea for him to participate.
Okay, I'll be calling him right now, Judge.
Thank you.
This is Mr. Johnson.
All right, anyone that's not required to speak, mute yourselves. Otherwise, we will have to do that ourselves.
Mr. McCurley, what case are you here on?
I'm on Johnson's case.
Okay.
Nice tie.
Your Honor, I just spoke with Mr. LaRue. He's going to be joining the Zoom meeting in just a moment on Mr. Johnson.
Oh, we will be honored. Especially if he appears like Mr. McCurley.
Morning, Judge. Are we doing Mr. Johnson now? I apologize. I was in 612. I'm not hearing. Judge, you're muted.
I'll unmute myself. Okay. Good morning, Mr. LaRue.
Morning, Judge. I apologize. I was in 612 call.
Okay.
Are we ready for Mr. Johnson? Is he in custody?
Yes.
19 CF 2663, People of State of Illinois versus Aaron Johnson. Defendant is present. Graham McCurley has filed an appearance. I'm not sure if he's actually been given leave to.
Yeah, he is present. I don't know.
People by Ken LaRue. Your Honor, it comes before you for a variety of motions. I know Mr. McCurley has filed a motion to suppress, but also the defendant has filed a pro se motion to proceed without aid of an attorney.
But oh, okay.
I've spoken.
Mr. McCurley, are you still representing the defendant?
Well, I have filed my appearance, Your Honor. I haven't been given leave to file my appearance. There was another attorney on the case who I believe withdrew from the case for Mr. Johnson. Went to the jail to see Mr. Johnson. Mr. Johnson decided to retain me. And I've since then spoken with Mr. Johnson about various strategies.
Johnson, is Mr. McCurley representing you?
Yes, he's my private attorney. I want to hear my motion to proceed pro se though. Yes, he's part of my counsel. He's private, but I would like to hear my motion to proceed pro se, Your Honor.
Well, I only hear motions from attorneys. Sir.
I'm asking to hear my motion to proceed pro se under my Sixth Amendment.
Oh, you can have your cake and eat it too. You cannot have your attorney.
Okay, all right. I don't need my attorney then, Your Honor. I don't need him.
So
he's no longer
fire your attorney?
Sir?
So you want to fire your attorney?
Yes, sir.
And can I ask you, you don't want an attorney to represent you, right?
No, I want to proceed pro se.
Can I ask you which law school did you graduate from?
Which law school?
Yes.
I didn't graduate from law school.
So you can practice law.
I don't have to graduate law school to exercise my Sixth Amendment of the U.S. Constitution.
I understand, but
Article 1,
you also understand that you will be held to a standard
yes, sir.
Of a lawyer.
Yes, sir. I comprehend, sir. Yes, sir.
Okay, so long as you understand that, what's your level of education, sir?
I have my associate's degree in college, sir, and I'm continuing learning.
In the jail, practicing, learning from other jailhouse lawyers. Is that what you're doing?
I don't even know how to respond back to that comment, sir.
No, I understand that, but you have the chance, and I will afford you the chance to have an attorney represent you.
Okay. I just want to hear my motion proceed pro se, sir.
All right.
Beretta versus California. I know you're familiar. I can't talk with it.
You understand that you're charged with a very serious offense.
Yes, sir.
All right. Okay.
If I may add something, Your Honor, I have advised Mr. Johnson that it's in his best interest to keep, if it's not me, that he's hired to have someone as his private counsel. I've advised him of this. There's a situation regarding whether or not he can have custody of the discovery, and I believe that's why he wants to proceed pro se.
This have anything? This
Okay,
have nothing to do with my discovery, Your Honor.
Yes, sir. I'm hearing from your attorney now.
Your Honor, I don't understand why he's talking right now. If I am proceeding to go pro se, this have nothing to do with my discovery. This have everything.
So you don't want Mr. McCurley to represent you, right?
Your
Mr.
Honor.
McCurley, I have tried to stress to the defendant the importance of being represented by an attorney.
Your Honor, I want to represent myself, Your
Can
Honor.
you be quiet, please? So, but it seems like we're not getting anywhere. The defendant is creating all kinds of commotion. I will discharge Mr. McCurley because the defendant at this time tells me that he doesn't want his private attorney to represent him. Mr. McCurley, do you suffer from any mental illness whatsoever?
No.
No, Mr. McCurley, I'm sorry, I meant Mr. Johnson. Mr. McCurley, my sincere apologies, sir. No. Mr. Johnson,
Yes, sir.
You do suffer from a mental illness?
No, just post-traumatic stress.
Okay.
From the legal system, Your Honor.
Well, I'm going to consider my ruling about discharging the attorney at this point, and I'm going to have the defendant evaluated for fitness.
I don't need to be evaluated, sir. I'm exercising my Sixth Amendment right.
But the way I see you, the way you appear, the way that you're talking, it appears to me that I need to make certain, sir, and the fact that you told me that you suffer from post-traumatic stress syndrome.
Your Honor.
Therefore, it is incumbent.
Your Honor, I am exercising my Sixth Amendment right.
You're constantly interrupting me. That's what I am going to mute you so I can rule.
Your Honor, I'm going to file a motion to dismiss my case based off denial of counsel. I'm asking to exercise my Sixth Amendment right.
Okay, but based on denial of counsel, yes, sir. I will now order a fitness evaluation. And
I told you I have my associate degree in college, Your Honor.
I understand that doesn't.
It's not
an equivalent to a fitness evaluation, sir.
I haven't said.
Sorry, I don't know why.
Fit.
Sir, could you please stop interrupting me? I will set the matter for when's the trial. Do we have a trial date on this? What stage are we in? Mr. McCurley, you're still on the case because I did not detect the fitness issue to begin.
That's fine. The case is set for trial in September by agreement of the parties, and probably because the coronavirus.
I haven't agreed to anything, Your
Honor. Sir, your attorney did.
This is my first court date since February 14th, Your Honor. I haven't been in court since Valentine's Day. When have anybody been? When McCurley have not
We're
been
under emergency order, sir. We're under emergency orders here.
Under my motion,
According to
under the
the
motion I
opportunity-
put in the motion for emergency court call. I did that.
Okay.
Not my attorney. I'm here to hear a motion to proceed pro
Sir,
se.
I'm sorry, from what you're saying, you know, that enhances my belief that you need to be evaluated. And I will continue the matter to July 16th for status of the defendant's fitness.
Your Honor, the next motion
At
I'm going to
1:30.
deny counsel.
At
Put in denial of counsel
1:30.
because my lawyer is fired. He's fired. My lawyer is
I
fired.
understand, sir, if you're not fit to stand trial, you're not going to be able to either fire your lawyer or proceed without an attorney.
Trial, fit to stand trial, sir. There was no trial for the next year.
Yeah, we'll see you then, sir.
You violated my constitutional rights, sir. You violated my constitutional rights, and I'm putting in a motion about this, sir.
What? All right, we'll see you at 1:30 on the 16th. We're done.
Thank you, Judge.
Thank you. Mr. LaRue.
Your Honor, I have Michael Chavez with Mr. Reinhardt, if Your Honor would like me to call that.
You may so do.
Okay, thank you. This is People versus Michael Chavez, 19 CF 1414. People by Ryan Kale. The defendant is present. Defendant's attorney Eric Reinhardt is also present. All parties are appearing through a Zoom virtual proceeding this morning. The matter is before the court on the defendant's motion requesting to be allowed to use cannabis consistent with his medical marijuana card. I'll let Mr. Reinhardt speak to his motion.
Good morning, Your Honor.
Good morning, Mr. Reinhardt.
Your Honor, Mr. Chavez is here. He contacted me. He is on probation. He is, I believe, on probation for a class 3 theft. The probation department said that we should talk to the court because paragraph 4 of the probation order refers to cannabis. I would note for the record that the cannabis is prohibited under the probation order. That's certainly understandable. But since entering into the probation order, Mr. Chavez has received his medical marijuana card. I've provided the Department of Health documentation to Mr. Kale, as well as the certification from a medical professional. So, Your Honor, very respectfully, we would ask to amend paragraph 4 of the probation order and allow Mr. Chavez to use cannabis consistent with a medical marijuana card and medical supervision.
Mr. Kale, do you agree with that?
Your Honor, I would defer to the court on this. I did speak with probation.
Fully negotiated plea, I'm sorry. Then you're not going to defer to the court on this.
Your Honor, based upon my conversations with probation, I will not object to this. I'll agree to it. However, if the court were to grant this, I would request that any order that Mr. Reinhardt prepare also specify that.
I'm not conducting a hearing, sir. Mr. Kale, if I conduct a hearing, I want to hear from experts. I want to hear what the defendant suffers from, why he needs medical marijuana, if he does. And the restrictions of probation are much more stringent than whoever provides him with a medical marijuana card. I need to hear all those things. So
You'd like to set it for an evidentiary hearing with a doctor?
But of course.
What's that? I'm sorry, Judge, I'm just having.
Of course, I would want to, but I don't see the urgency right now unless Mr. Kale and you have an agreed order to amend it, which I may reluctantly follow it because it's a fully negotiated.
Okay. Well, it sounds like Mr. Kale and I have an agreed order.
Then,
Mr. Reinhardt, here, what I would request, if I could, we could either pass the case, set it for another date. I need to speak with probation further about this. Probation provided me information that I can share with the court, but I'm not in a position to agree to this at this moment.
And Mr. Kale, the defendant doesn't have to ingest marijuana. He can take oils or anything that's an alternative that would not be mind altering while on probation. But those are comments that I would give you. If you leave it up to me, that's what I would consider. All right.
I guess we should, I don't know how your Honor's calendar looks today. I want to be respectful of your calendar. I guess we should pass this because I thought Mr. Kale agreed a moment ago, but that's okay. Mr. Kale can change his mind.
Kale, by no means I meant to, by giving you what the parameters of my restrictions would be or what I would consider during a hearing. Don't let me by any way tell you how to make your decision.
Your Honor, if we could pass the matter, I would like to speak with probation further to.
You brought that up. Yes, sir.
Thank you.
I'll pass it till later on this morning. How long do you need, Mr. Kale?
Hopefully just 10 or 15 minutes.
Okay. We'll pass in the case.
Okay.
Thanks, sir.
Thank you.
Stand by, Mr. Reinhardt.
Your Honor, I think Anthony Benjamin is sitting in jail. I think they are ready for that case.
Okay. Yes, but we cannot hear you, Mr. Zermino.
Oh, you guys can't hear me?
No, you sound like you're far away and the cell phone company is down.
Any better? What about, let me try this.
Now it's better.
Is it better now?
Yes.
Oh, perfect.
What did you do?
I changed the microphone to my headphones from my laptop. I don't know.
Oh.
Maybe that did the trick, who knows? Okay, this is People of the State of Illinois versus Anthony Benjamin, 19 CF 248.
There's a lot of noise with that, so you understand.
A lot of noise for me?
Yes, cracking noise coming from your system.
Oh, yeah. Let me see.
Can you hear me?
Now it's better.
Anthony Benjamin, 19 CF 2488. People by Assistant State's Attorney Eduardo Zermano. The defendant is present in custody of the Lake County Jail, represented by his attorney, Mr. Powell. The case comes before the court today for a bond review.
Good morning, Judge.
Good morning, Mr. Powell.
Judge, I asked that this be brought up today.
Yes.
For bond review. There is a pretrial bond services report. Judge, the bond is currently $1 million, which I don't think anyone can argue that that's certainly appropriate. I believe it's excessive. Mr. Benjamin has lived in Lake County his entire life. He's got significant family ties. He's got 4 children in the area, and I understand the seriousness of the charges. But I believe he does have a place to stay. It appears that pretrial had some issues with verifying that. However, I believe he would be able to stay in Park City.
Oh, you believe? Yes.
Correct. Well, just based on the information on page 2, I believe there's an address in Park City that was given. And Judge, he appears to be a moderate risk according to their assessment. And Judge, again, he's a public defender client. I'm asking the court to reduce the bond to an appropriate amount based on his means and the charges. In my motion, I did ask for a reduction down to $100,000, but it appears Mr. Benjamin may be able to post, unfortunately, no more than $5,000.
Mr. Zermano, do you agree with all of this?
Your Honor, I think the court should be aware of what I believe is the reason for the high bond. When this case first came through bond court, there was a threatening a public official charge attached to it. It wasn't indicted that way. I don't know why. I just became familiar with this case. I can always add it if I need to, but I think the Gerstein for that was part of the reason why it was so high. And I don't know if the court would like to hear that.
To me so I can
yes.
consider it.
So after defendant was arrested on one of the final buys that are alleged in the indictments, he threatened one of the officers that he was going to kill them. He said that he had capital murder on his record, which is verified by the pretrial bond services. He was not, it was a mistrial, but he was charged with it, and he would do it. He threatened to kill his family and his children, and he would also find the undercover officer and kill them as well. And so with the pretrial report, it is verified that he was in fact charged with murder in 2008, attempt murder. I'm sorry, attempt murder in 2008. So that's one of the reasons. I think that's why it was so excessively high. As far as bond, Your Honor, I know $1 million is a lot. If the court declined to lower it, I'd ask for no lower than 500,000.
Well, there's something that I have to consider, Mr. Plum. But under the circumstances, I will not reduce the bond.
Your Honor, we do have
Deny the motion.
Your Honor, if I can verify something with the court, I spoke with Mr. Powell yesterday. Maybe Mr. Powell has checked his file. He mentioned he did not have a lot of the discovery that I have in my file. I checked CRIMS, and it looks like we have filed multiple supplemental discovery disclosures. I just want to clarify that with the court, whether Mr. Powell has additional supplemental discovery or not.
Mr. Powell, were you the original attorney on this?
I was not, Judge. I inherited this, so I can't really speak to what was tendered to the previous attorney. I can only...
The previous attorney was a member of the public defender's office?
Correct. Yes.
Okay, then. All right.
And
you have the file, in other words.
I certainly do, Judge. However, I do not believe I have everything. Certainly, I don't have everything that was tendered. So I would ask the state if they would be so kind as to perhaps retender anything that was submitted on a disc or any sort of digital form.
It may be a burden on the state to make additional digital copies. I don't know how voluminous that would be, but if it is doable, Mr. Zermano, can you do that? And
absolutely, and I know we have the
discovery process.
Yeah, I will tender. I think Mr. Powell, he said he only has our original discovery, so anything after that, I'll make a copy for Mr. Powell.
I appreciate that. Thank you very much.
Thank you, folks. When is the next date?
I think our next date is July 16th, from what I can tell here. It's a few days short of the trial date.
All right, July 16th then.
Thank you.
As everything stands now, I don't know if you folks want to proceed to trial, but you may re-examine your position at that time.
Your Honor, and I know we have tendered an offer. I don't think that's it's been rejected, so we'll keep talking.
After Mr. Powell has all the discovery, first he wants to make certain that he's got the discovery. Correct, Mr. Powell?
Please, thank you.
All right, we'll see you July 16th at 1:30.
Thank you.
Thank you.
Your Honor, we might also be able to call non-custody Melody Pratt as well.
Well, if you folks are ready.
I'm ready on that.
Oh, okay, Ms. Raish. All right.
This is People of the State of Illinois versus Melody Pratt, 11 CF 420. People by Assistant State's Attorney Eduardo Zermano. Defendant is present, not in custody through the Zoom video conferencing, represented by her attorney, Ms. Raish. This case comes before the court for status of a petition to revoke. And Your Honor, Ms. Raish and I spoke yesterday. This is an old case alleging she didn't report to probation.
Mr. Reinhardt, mute yourself. Stop making noise. Go ahead.
And Your Honor, we did speak with probation It looks like in 2011 she was sentenced to probation in Kenosha, and she successfully completed that. And for the last 9 years, she has been arrest-free. Um, so what we propose for the court today is defendant would admit to paragraph 3 of the PTR and just be the 410 probation would be revoked, terminated unsatisfactorily, and judgment would enter. I did send an order to the T-610 courtroom for
Well,
your
if it's,
consideration.
if it's terminated unsatisfactorily, that means the conviction will enter on the record.
That is correct, Your Honor.
I couldn't hear that. I'm sorry.
The clerk has a little problem. You cannot revoke and term.
One or the other.
Oh, I see. The intention is for the conviction to stand since it was 410 probation.
That's correct.
Whatever language, I'm not sure which the language gets you there.
Just a second, let me see. We'll find the codes. It's like the medical office sending codes to the insurance.
We can redraft the order if you'd like, Your Honor, or you can amend it on its face, whatever you prefer.
You know how long it's been since Windows was invented, and no codes need to be, those codes have to be entered, but we're still using them. The clerk is making the
That
correction.
makes sense.
All right.
For the admitting, entering, or terminating, and entering.
All right. Also order that. Then, Ms. Raish, are you waiving further advisal since there's not
I am, Your Honor.
more? But I will advise your client that this will be permanently on your record, ma'am. You understand?
I understand. Yes, Your Honor.
All right. Also, go along and enter a conviction on this matter. The plea of guilty was taken a long time ago. And judgment on all outstanding fines, fees, and court costs.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
No
Right, you're set,
further,
Ms. Pratt.
no further advisals are necessary, correct, Ms. Raish?
Yes, Your Honor. Nothing more is necessary.
No more appeal rights. The appeal rights have been given, everything. Okay, everything applies. Thank you.
Thank you, Judge.
Ms. Pratt,
Yes. Thank you, Your Honor.
you're very welcome, and remove yourself.
Okay.
Thank you.
Judge, Ms. Raish and I have an arraignment I can call.
Yes, you may. Good
Passion
morning.
Harris.
Yes.
This is 20 CF 763, People versus Passion Harris. Kyle Doyle for the state. Sarah Raish present for the defense. Ms. Harris is present. All are present via Zoom. Matter comes before the court today for arraignment.
Are you waiving formal reading, Ms. Raish?
I am, Your Honor.
Ms. Harris, you understand that you are charged with the offense of aggravated battery to a child. They say that you, being over the age of 18, knowingly without legal justification, caused bodily harm to JK, a minor child under the age of 13, in that you struck JK about the body. Count 2 charges you with aggravated battery to a person with intellectual disability. They say that you knowingly without legal justification caused bodily harm to SH, a minor, a person with a severe and profound intellectual disability, in that you struck SH about the body. You're also charged with the offense of domestic battery. They say that you knowingly caused bodily harm to JK, a minor, family or household member of yours, in that you struck that person about the body. Count 4 charges you again with domestic battery, but they charge it in the alternative in that you made an insulting or provoking nature with JK under the same circumstances and committing the same act as in count 3. Count 5 charges you with the offense of domestic battery. They say that you knowingly caused bodily harm to SH, a minor, being a household member of yours or family member, in that you struck that person about the body. Count 6 charges you with the same offense, alleging the same facts and acts in that, but they say that you made knowingly contact of an insulting or provoking nature. Tendering formal pleas of
Not guilty, Your Honor.
which shall be entered and received. The usual and customary discovery will be ordered. State 7, defense 14, all motions in writing within 21 days. The matter will be set for trial. Which trial call are you looking for? Realistically, are you looking for, do you think that this matter will be resolved, Ms. Rage?
I don't know, Your Honor. I have not viewed any discovery in the matter. Certainly willing to attempt to resolve it. If we could set it for the August trial call for now.
All right, I'll set it for August 24th for trial, but I will give you an earlier resolution date. So how's the 23rd of July?
That should be fine, Judge.
At 9 o'clock.
Thank you, Judge.
Thank you, ma'am. Thank you, Ms. Harris.
Thank you,
Ms. Harris,
Judge.
I will call you, Ms. Harris, okay?
Yes, ma'am.
Okay.
All right, you may now remove yourself from the courtroom. Anyone else ready, or should we take a recess and wait for everybody else now?
Your Honor, this is LaTanya Burton. I've been ready, Your Honor, on Mr. Haynes. He's been on a call for a while. I do understand that Mr. Lorenz, he's in another court call. Judge, can we just get a continuance on this for arraignment?
How about bypass it and we'll try to track him down? I don't know where he is.
I just have some other meetings coming up.
But we can proceed with Mr. Quilty now. And Mr. Quilty, are you ready? Are you waiting for Mr. Lorenz too? No? Mr. Quilty. Call in Mr. Quilty. He's unmuted, but he's not there. Mr. Quilty. Oh, unmute yourself, Mr. Quilty.
He is unmuted. Must be something wrong with his computer.
Mr. Quilty, your computer is not working. In the meantime, Mr. Lawrence is here. Ms. Burton, are you there?
I'm right here, Judge.
Mr. Lawrence is present.
Thank you.
In this court call, in other words.
Good morning, Your Honor.
Good morning, Mr. Lawrence. Deja vu all over again, Mr. Lawrence.
I'm sorry, Your Honor?
Deja vu all over again.
I'm sorry, Your Honor. I've been in 3 different courtrooms, so I...
Well, then schedule your cases in different courtrooms. We have different dates for different judges. Make certain that you prioritize.
The one that looks better than my pen scratching out, so can you sign that over?
Okay, yeah. Yeah. Are you ready, Mr. Lawrence, to call the case for Ms. Burton?
I am, Your Honor. This is People of the State of Illinois versus Michael Haynes, case number 17 CF 1537. People by Ken Lorenz, the defendant by his attorney, Ms. Burton. The defendant is present, appearing virtually. The matter comes up for arraignment on the petition, revoke, and bond hearing.
And bond hearing, are you asking for the bond be set?
Your Honor, I reached out to his probation officer, Mr. Tavares, who got back to me earlier this month on his expectations for the defendant and what he wanted to try to do before the next court date, including drops. I have not heard back as far as an update with those drops from Mr. Tavares. So at this point in time, we'd like to reserve on bond, not asking for a cap or recommending another type of bond.
Then, Ms. Burton, are you waiving formal reading? Good morning.
Good morning, Your Honor. Yes, we can waive formal reading of the petition to revoke, and I would like to enter a denial.
Yes, ma'am. I will then advise your client that you, sir, violated conditions of your probation in that you had unauthorized outings of movements from the correction-based community center. And you committed a new offense, reckless driving, and improper lane usage, as alleged in cases 19 TR 85670 and 19 TR 85671. The formally tendered denial will be entered. Received. The matter will be Mr. Quilty, I think you're on now.
But Judge, I went to my phone because the brand new laptop, for some reason, I just can't get the sound.
You need the better IT person, the person behind, besides yourself. But we're gonna mute you right now so we can hear the others.
Thanks.
Or if you don't talk or if you don't move, then we'll finish with this case. Ms. Burton, when are you looking for a status date?
Yes, Your Honor. If we can have a status date in about 3 weeks, Judge, is that appropriate for the court?
Absolutely, it would be.
Let's try the 16th of July if the court is available.
I thought that's like 4 weeks. I thought.
I'm sorry, the 9th. I apologize. The 9th of July, Your Honor.
The 9th at 1:30. I at 9 o'clock. I'm sorry.
Okay.
9 o'clock. Your client is not in custody. All right, Mr. Haynes. Remove yourself from the court call, and we'll see you then.
Have a good day.
You too, Ms. Burton.
Thank you.
Thank you, Honor.
I am admitting him. He went back to.
No, I put that one in the waiting room. He's in here on his iPhone and his laptop.
Oh, sorry.
So I put his laptop in the waiting room.
Oh, that's
and
what
then he
happened.
needs to unmute now. He's unmuted on his iPhone, so we can hear him on there.
All right,
So,
Mr. Quilty.
Yes, Judge.
We can hear you loud and clear.
there we go.
All right, who's got Mr. Quilty's case?
Mr. Zermeno does.
Mr. Zermeno.
Which case is that? I thought my last one was with
It's
Mr. Powell.
Tiffany.
Did this yesterday, and the judge reduced the bond, but would not change the order where they couldn't have any contact, the husband and wife. And as a result, she had to move out. They live near, obviously, northern Lake County. So the only place she could stay was with her aunt who lives a few miles away, but it's across the border. Pre-trial letters stayed there last night, but said she will need an order from the judge allowing her to live with her aunt, which is just across the border in Pleasant Prairie.
If that's an agreed order, if that's an agreed order, I'll be glad to.
I have no objection.
Well, if you submit an agreed order signed by both parties, I would not conduct a hearing. That's what I'm trying to tell you.
Yes, Mr. Quilty, I can draft an order, sign it, and send it over to you. And then I don't know what you can do on your end.
You know what? If you want, since I'm not in my office right now. The easiest way I think is I'll agree to it. You put I agree to it. Just send it over to pretrial.
Well, if you both agree to it, I will so order.
Okay.
And you can submit the order. It doesn't have to be signed by both of you now.
Okay, I will take care of that, Mr. Cote, and I will get you a copy of that.
The defendant is not present, right?
No, she is not.
Okay, just to make
It's
sure.
for Tiffany Nielsen, Ed. She's gonna be the one moving out of the house.
All right, okay, it's to accommodate the previous court order.
And
All
that's
right.
Pleasant Prairie.
Okay.
Pleasant Prairie.
All right, yes, the
What
defendant
state of
will be
Wisconsin?
allowed to
Pleasant Prairie,
leave the
Wisconsin.
state for that purpose.
Okay, if I have any questions, I'll call you, Mr. Cote.
It sounds great, Ed. Thank you. Appreciate your help. Thanks, Judge, for your patience.
You're very welcome. We'll see you next time. Take yourself out of both.
What's that?
Take yourself out.
I am. I'm just doing it now, Judge. I thought you said something.
All right, I'm going to remove you from the other one. Okay. All right, who's next and if ready?
Judge, I have Alonzo Pipes with Mr. Lorenz.
Okay, Mr. Lorenz.
Yes, sir.
I guess there he is.
This is People of the State of Illinois versus Alonzo Pipes, case number 18 CF 2421. People by Ken Lorenz, the defendant by his attorney, Mr. Powell. The defendant is present, appearing virtually. This matter comes up for status of bond review or to set a bond on the PTR. The state has filed and tendered a copy to the defense, a motion or an application to review and set a cash bond.
All right, I'll set the matter for a hearing and it'll be in-person hearing in the courtroom. We'll open up the courtroom. When, Mr. Powell?
When, Judge?
Yes.
Well, Judge, if I may, just so the court's aware, I have been in communication with Mr. Pipes' probation officer yesterday and on Tuesday, and she did indicate that he is reporting. He reported yesterday. He tested negative for alcohol and cocaine. There was a presumption of him being positive for cannabis, but that's based on prior usage. And both Mr. Pipes and probation had contact with the Lake County Substance Abuse Program, and they're going to start treatment via Zoom. He completed a intake, which was confirmed by probation, and he's scheduled to begin the actual classes on June 22nd. And again, that would be through Zoom. Mr. Pipes recently, again, this is all according to probation. I have an email from probation. He brought his medication when he saw his probation officer yesterday, and the medication is actually going to be used in lieu of marijuana. It's a prescription
Has it been arraigned on the petition to revoke?
Judge, I believe that occurred on the last court date.
Okay. Have you reviewed the allegations on the state's application?
I have, Judge, and that's why I'm indicating to the court specifics with regards to what's happening today, update that I received from probation. And the reason I'm doing that is the court asked me when I want to have this in-person hearing for bond review. And my thought was, if I present this information to the court regarding what is happening right now, and again, this is all according to probation, a longer date would be appropriate, given that he is reporting and he is on track with treatment, both with substance abuse and his psychiatrist. I think it's appropriate to ask for a longer date.
When there is an application to increase bond or set bond if he hasn't been set it, and there are serious allegations alleged in that application, I must treat it with urgency. Therefore, I will set the matter for hearing, in-person hearing at 9 o'clock in the morning on the 25th of June. The courtroom will be opened up and it'll be an in-person hearing. Okay?
Thank you, Judge.
9 o'clock. And if the state has witnesses, if I'm setting it for hearing. the state must present the witnesses. If the defense has witnesses, the defense may present the witnesses. I will open the courtroom with taking the proper precautions. All right.
Thank you, Mr. Pipes. I will
Defendant
call you
is
later.
ordered to be present. The defendant is ordered to be present, as I indicated. All right, Mr. Pipes, you heard that.
Yes, Your Honor.
All right, we'll see you then.
Mr. Lorenz, can you call Mr. Fuza's case, Omar Rodriguez?
Sure. Yes. This is people of the state of Illinois versus Omar Rodriguez. Case number 20 CF68. People by Ken Lorenz, the defendant by his attorney, Mr. Foos. The defendant is present, appearing virtually. The matter comes up for arraignment. The state has tendered initial discovery to the defense via email yesterday, being KL1 to KL25.
Good morning, Judge.
Good morning, Mr. Foos.
Judge, my client requires the assistance of a Spanish interpreter.
All right.
If we could ask the case judge to have an interpreter.
That's the case. You should have informed us, or at least Mr. Lorenz before he called the case. All right, we'll put the interpreter on.
Thank you, Judge.
Anything else that's ready? There's a Swan on the call. Who's got it?
Judge, that's my case, and that's with Mr. Barrel. All I'm asking for is a short date for plea. I'm sure we can have another prosecutor stand up on the case.
Like Mr. Lorenz was right there.
Or Mr. Zimeno. I've texted Mr. Barrel, and he's okay with just getting a date, having somebody else step up for him.
All
It's
right.
19 CF 2216 for whoever wants to step up on that.
I can.
Mr. Barrow asked me to let him know when this case is ready to be called. If we can wait to see how quick we can get in, I will.
I just texted him.
Okay.
And he's okay with that,
Okay.
with calling it.
All right, this is people of the state of Illinois versus Camry Swan, 19 CF, excuse me, 2216. People by Assistant State's Attorney Eduardo Zermano on behalf of Mr. Barrel. Okay, the defendant is present, I believe. I know his video's turned off, but I'm assuming he's there.
I'm here. It's a girl.
Present via Zoom video conferencing, represented by Mr. Powell. Case comes before the court today for status.
Judge, this is going to be a plea, and I would ask for July 15th or July 16th for plea.
One is lighter. Let me check. Of course, we don't know what's on. I'll try 16th first. July 16th at 9 o'clock.
And just for the record, Mr. Barrow wanted me to let the court know initial discovery has been tendered. Standard discovery motion to propose discovery orders have been filed with the court. July 16th works.
Yes. Thank you.
Okay, Ms. Swan, you can leave and we'll be in touch, okay?
Okay, thank you.
You bet.
All right, we'll take a recess and wait for the Spanish interpreter.
Interpreter's here.
Oh, Spanish interpreter is present. See, we're very efficient here. Okay.
This is people of the state of Illinois versus Omar Rodriguez, case number 20 CF68. The people by Ken Lorenz, the defendant by his attorney Joe Foos. The defendant is present, appearing virtually, out on bond. This matter comes up for arraignment.
Esta es el número de caso 20 CF 605. El caso es del señor Omar Rodríguez. La fiscalía está aquí por Ken Lorenz y está aquí para la revisión de la fianza.
Good morning, Your Honor.
Good morning, Mr. Fools. Are you waiving formal reading of the indictment?
That's correct, Judge. Enter pleaded not guilty.
Señor abogado, usted está renunciando a la lectura formal y renuncia but interpreter, can you repeat that again? You waive formal reading?
Formal reading, yes.
Yes.
And he said yes.
Yes.
And I will proceed and arraign the defense.
All
right, Mr. Rodriguez.
Señor Rodriguez.
You are charged with the offense of domestic battery. They say that you, knowingly and without legal justification, caused bodily harm to Bernice Bravo Salcedo.
Señor, dice, se le acusa de que causar daño corporal a sabiendas de que usted no tenía esta posibilidad de hacer esto a la señora Bernice Bravo.
Who is a family or household member of yours.
Es un miembro de familia o una persona que vive en su casa.
In that you struck her about the body.
Y que usted la golpeó en el cuerpo.
And you had been previously convicted of the offense of domestic battery.
Usted también anteriormente ha sido una víctima de violencia doméstica.
Count 2 charges you with the same offense, but they charge it in the alternative in that you made contact, physical contact of an insulting or provoking nature.
Usted tiene encargo de hacer un contacto físico de naturaleza insultante y provocadora.
Alleging the same acts under the same circumstances as in count 1.
Se alega lo mismo en las mismas circunstancias que en el cargo número 1.
All right, tendering a plea or pleas of
not guilty, Your Honor.
Which shall be entered and received. The usual and customary discovery will be ordered. State 7, Defense 14, all motions in writing within 21 days. The matter will be set for trial.
Esta cuestión es un acuerdo de no culpable. La fiscalía tiene 7 días para presentar las pruebas. La defensa tiene 14 días para presentar su defensa y 21 días en total para resolver el caso. Y esta cuestión se va para el juicio.
Which trial date are you looking for, Mr. Fools?
¿Qué fecha del juicio quiere usted para irse al juicio, señor Fools?
Mr. Lorenz.
The September trial call, Judge.
Fecha de septiembre para la llamada del juicio.
Case management conference when?
I'm sorry, Judge, did you say September 29th?
Yes.
Thank you.
Del septiembre 29 el juicio. Abogado, usted dijo para la conferencia de la llamada del caso.
Judge.
September the 28th. Did I say 29th is a Tuesday?
Yes, Judge.
28th, I'm sorry.
Septiembre 28.
Thank you for correcting me, Chris.
Judge, may we have a case management date, perhaps mid-July, July 16th?
All right.
Señoría, podemos tener una casa del manejo del caso.
For a case management conference.
A la mitad de julio.
Judge, just 2 other brief matters. I'd be asking that the defendant's bond conditions regarding his curfew be modified to allow him to work past 6 p.m. I believe right now it's a curfew at the discretion of pretrial, 6 to 6. He's a painter. He's trying to work some extra hours. We'd like it just modified so he could work past that time.
Estamos solicitando aparte otra cuestión. Estamos solicitando que el toque de queda se modifique. En este momento está trabajando tiene que trabajar más después de las 6 de la tarde. Su toque de queda está siendo vigilado por el Departamento de Prisión Preventiva. Ahorita está de 6 a 6 y queremos que se haga esta modificación.
All right, the state has no objection, I take it?
To the curfew modification, no, Your Honor, as long as it's verified and approved by
Correct.
Pretrial Bond Services.
Also order then that the defendant be allowed to work past 6 o'clock, so long as it's verified that he is at work by pretrial.
Oh, esta fianza, el fiscal dice que esta no tiene protesta por la modificación de la fianza. El juez indica que esa está autorizando la modificación siempre y cuando esta sea verificada por el Departamento de Prisión Preventiva y puede ser extendida más de las 6 de la tarde.
Judge, there's one other matter as well.
Hay otra cuestión, señoría.
Judge, there's a criminal order of protection as part of this case that restricts Mr. Rodriguez's ability to see his children. He has not seen his children since January 2020. There's a pending Lake County divorce case, 20D439. I would be asking if the court would enter an order allowing Mr. Rodriguez's criminal OP to be modified so that he could see his minor children pursuant to any order entered in the divorce case.
El abogado está,
something like that for a hearing.
Yes.
El abogado está solicitando que el señor tenga la oportunidad de estar restringido de ver a sus niños. No los ha visto desde enero del 2020. Él vive en el condado de Lake y el número de caso que tienen es 20D430. Está solicitando a esa señoría que por favor le dé la oportunidad de ver a sus hijos.
All right, I must set it for a hearing unless you have an agreed order, in which case you may modify it. Where was the criminal order of protection entered? And perhaps they can hear it in that courtroom.
Se tiene que ir a un juicio antes de que se pueda utilizar esta orden.
It's following the felony, I take it, so it's here.
Yes,
Están viendo el número de caso.
I'll set it for the 16th for a hearing unless you have an agreed order.
Judge, I'll motion up if necessary. I don't want to set the criminal order unnecessarily for hearing and have the victim have to appear during this time.
All right, I will.
Esto se va a fijar para que se vaya.
Your motion, or maybe you should make your motion.
Yes, Judge.
Esta orden se va a hacer a través de una moción para poder ver si se puede modificar. El juez no quiere que haya ningún tipo de contacto con la víctima.
Thank you, Your Honor.
Se va a hacer posteriormente.
All right.
Thank you, Judge.
The interpreter, and we'll see you folks.
Nos vemos después, señores.
Thank you, Judge.
Gracias, señoría.
All right, next.
Your Honor, are the cases scheduled for 1:30 going to be heard this morning like yesterday?
There is a Chisholm, I think, for 1:30.
And we're doing that in the afternoon?
Yes, 1:30.
Okay.
And the reason is that somebody else has priority and they get the prisoner. I don't know how that works. Don't ask me. I don't set the rules, I just follow them.
Okay.
Question now. We have Mr. Reinhardt smiling. Oh, actually, we have his campaign picture and smiling.
No, it's just now, Judge.
Oh, now you're live. Yes, sir. What was it, Mr. Reinhardt? I'm wrong again. Is that what you're saying? Who's the?
Yes, I'm ready.
Who's the prosecutor? So.
Mr. Cal.
Mr. Kale, you were supposed to contact the probation officer. Isn't that why we texted?
I'll send him a message. Maybe he stepped away.
All right, we'll take a little recess. Wait for Mr. Kale this time. Okay, folks. I guess you're ready, huh?
Hi, Judge.
Hello, Mr. Kale. If you show me your face,
Yes.
great.
There we go.
Thank you.
Your Honor, I believe Mr. Reinhardt is connecting by phone. Is Mr. Reinhardt there?
Yes, I'm here. I am with my wife, and we are driving our children to a doctor's appointment. So I'm
I
here by
hope your
phone.
wife is driving.
My wife is driving.
Very good. Your Honor, I'm not sure if Mr. Chavez is still here, but I was able to get more details from probation. The bottom line, Your Honor, is that we do have an agreed order to allow the defendant to use medical marijuana consistent with a usage card. Mr. Reinhardt and I will sign that order, and we'll email it to your clerk.
They submitted.
Yeah, Your Honor, I sent the order to Mr. Reinhardt to sign. I don't know if since he's traveling, we may need to submit that through email later today.
It's fine, whenever.
The order is fine, Judge. The order is fine.
Well, yes, you have stated on the record that it is.
Okay.
You're in agreement, Mr. Kale. Since you prepared it, you may submit it.
Okay, I'll submit it without signatures then, since it was on the record, Your Honor, and I appreciate
it. On the record, and it's
Your Honor, it was not on the record. Your Honor, this part was not on the record.
Okay, I apologize. This is back on the record on People versus Michael Chavez, 19 CF 1414. The same parties are present. Your Honor, after having spoken with probation further, we have an agreed order allowing the defendant to use marijuana consistent with the medical marijuana laws, and I will submit that to the court through email in just a couple of minutes.
If that's your agreement, I'll so order then.
Thank you, Your Honor. I've reviewed the order, and I'm agreeing.
Thank you, sir.
Okay.
Have a nice day, folks.
Thank you, Judge. You too.
All right.
Thank you. Thank you for your time, Judge.
At 1:30 then.
I'm sorry, Your Honor. Was there a case up at 1:30 today?
Yes.
Oh, Chisholm. Okay, I believe that's Mr. Zermino. Okay.
Okay. We'll see you then.
Thank you, Judge.
Take care then.
Okay, you too.
I'll be in chambers if you need anything.
Thank you very much, Judge.
Sign that order. All right. Thank you.
Yes, I'll submit that.
Thank you.
Thank you, Judge.
Thank you.